Hi, thank you so much for coming and talking to our students. They're really excited to hear from you. Would you mind introducing yourself and kind of give them an idea of your journey and where you are and how they might could get where you are?
Thank you. I'm happy to do that. So my name is Audrey Mross, and I'm a partner in a law firm here in Dallas, Texas called Monk Wilson Mandela. I co-chair the labor and employment section, but I have not always been a lawyer. Actually, straight out of undergrad, which was Kansas State, I went to work for what at the time was the world's largest franchisee of Holiday Inns, happened to be based in Topeka, Kansas. And they decided to relocate the headquarters to Dallas, Texas, a long time ago, back in 1982, and offered all of us the opportunity to leave little Topeka, Kansas and come to Big D, which of course, as a 24-year-old, I went, yay, of course. So I came down here. I started off in the hotel and restaurant business for 5 years. I then briefly went over into the oil and gas business for 1 year. And then I transferred over into information technology with a company called MTech, which was then acquired by EDS. Some of you might recall the name EDS. It was actually led by Ross Perot back in the day. And at the time I joined them, they had become part of General Motors, and Ross Perot was just getting ready to think about leaving. And I think it coincided with his run to potentially be president of the United States too, if I remember correctly. Anyways, I did human resource work for 11 years. While I was at EDS, I had the opportunity to work extensively with both in-house lawyers and outside lawyers. And I had worked with lawyers in the past with my previous employers as well. But the difference at EDS is that I had a really good HR manager who felt it was really important for people to think about their long-term goals, and she wanted to do what she could to develop that. And almost on a lark, I said, well, you know, I've done quite a bit of work with lawyers, and you know what, I think I can do that. And to her credit, she encouraged me to pursue that, to study for and take the LSAT exam. And when I scored sufficiently high to have good standing, she then encouraged me to make applications to law schools, basically where EDS had operations, so that I would have the opportunity to continue working part-time while I was going to law school full-time. Since I was putting myself through law school, it was important to have that income stream. I got offers in DC, Detroit, and Dallas, and here in Dallas, it was SMU, and I went, yay, I don't even have to move. So I attended SMU Law School. I graduated from there in '94. So between my 11 years as an HR professional and the rest of it as a lawyer, I've basically been working in this same area, just wearing a slightly different hat for just over 40 years.
Now, I recently read your bio and you have some great distinctions. Can you share those?
Oh, well, thank you. That's so nice of you. I actually got one of them was refreshed today. I got the notice that for the second year in a row, I've been named to Best Lawyers in America list. I've also been on Texas Super Lawyers for, I want to say 12 years in a row, and also selected to the Best Lawyers in Dallas list this year, and have been on that list 5 times. So those are just little nods that are usually from your peers and from your clients, and then it's vetted by various committees to make sure that your attributes actually, you know, merit it. But yeah, I'm very pleased to be recognized by my peers as somebody worthy of being recognized in that way.
That is really cool, and I really appreciate you sharing your knowledge with the students. So,
Oh, I'm so happy to. I appreciate the opportunity.
All right, so we were going to talk about EEO, so the purpose of the EEOC and EEO legislation and how it relates to recruiting talent, staffing talent, the whole mire of issues.
Mm-hmm. Yeah, so the EEO laws have been around mostly since the 1960s. They flow from the civil rights movement during that time. And the simple idea behind them is that if a person cannot get a good education And if they cannot get a good job or keep a good job because they're driven away from those places by discrimination or harassment, then not only is it not good for them, it's actually really bad for us as a society. Because if you think about it for a minute, what happens to a person who cannot obtain either a good education or a good job? Not good things, right? I mean, I'm sure your mind's running with it, but unfortunately, some might resort to a life of crime. They might need various forms of public assistance. And when the Congress was debating these laws, they pointed all these things out and said, look, we as taxpayers have to foot the bill for all of those things. It makes no sense to allow that discrimination and harassment to continue. So that's why these laws were drafted. However, it's important to note they were drafted very narrowly to only apply in 2 places. Title VII, for example, applies in the workplace. Title IX, as you all know as students, applies to education. I've had more than one training session where a guy has come up to me after the session and said, well, my wife harasses me at home. Can I use that law against her? And I said, no, that's not a workplace and that's not a school. You're going to have to find another way to deal with that. But that's why the laws were put in place. And so they refer to what we call protected categories, things like race and age and gender, national origin, color, disability, the list goes on. The point being that those attributes have, in most cases, not every case, but in the vast majority of cases, absolutely nothing to do with the person's ability to do a job. And so they should not be considered when we're hiring, when we're selecting, when we're promoting, and they shouldn't come into play when we're deciding to fire someone either. So all of the employment processes are tainted if those factors are used in making an employment decision. The laws were put in place to tell employers, don't use those as employment criteria during any of those phases of employment. And oh, by the way, if you do, the person who is impacted by it will have recourse. They can come back to the agency and they can file a charge of discrimination, and the agency will investigate. They will also have a private right of action, meaning if they want to, they can file a lawsuit, either on their own, which is called pro se, or they can get a lawyer, and they'll have a limited amount of time after the agency proceeding to file a lawsuit. We'll get into it in a minute, but the people that can be sued is a lot broader than you might think.
That's very interesting. I've heard EEOC speakers at conferences before, and they talk about having a strategic direction or a strategic plan over the next 3 to 5 years. We're going to actively seek out these types of claims. And I think that disability is one of them down in San Antonio that they're looking for right now.
You are absolutely correct. And they put out their plan. It's published. Anybody can go to the website and read it. They put out a new strategic directive every year. And the ADA, Americans with Disabilities Act claims, has been at the top of the list for several years in the running. Other ones kind of come and go, sometimes in response to current events. So for example, immediately after 9/11, there was just a spurt of national origin claims of people who were, for instance, of Arab descent or Muslim in religion, being harassed at work on the presumption that surely that they didn't have anything directly to do with it, but they were somehow tied into these attacks against America. And so there was a little spike. And so they had a little push right then to try to help employers understand, we understand everybody's really upset about this event, but you have got to protect these people from this unwarranted discrimination and harassment. A really good place to go if you're interested in just seeing how these things ebb and flow is the EEOC's website. If you go to the homepage and you scroll all the way down to the bottom and you go down to the sector where there's information for employers, the bottom line says statistics. And if you will click on that, you will find both charge statistics and litigation statistics. Charges are when an individual, either a job applicant or an employee, files a charge. And then the litigation statistics are when the EEOC itself decides that one of those charges was so serious or the damage was so widespread that they took it upon themselves to file a lawsuit on behalf of that charging party. But they've sliced and diced the data in all different ways, and you can see things like how many charges were filed based on various employment actions. You can see how many were filed in different states. You can see hard numbers versus percentages. And what's really cool is the numbers generally tend to be a run of years, at least 10 years, if not more. So you can look at trends. I mean, you can look at, for instance, sexual harassment claims, and you can see, oh, they're going up, oh, they're going back down, and those types of things. It's a great source of information. And if you are going to go into human resources, and if you are a proponent of training within your organization of your managers and supervisors, that's a great place to go, because you can point to that list and you can show whoever's in charge of your budget, look, this issue is spiking, or this state that we're in is spiking. We need to do something about it. I feel like we need to allocate budget to do training so that our managers and supervisors are very well informed about how to handle these things. First of all, how to prevent them, but even more importantly, what to do when one of these problems lands in their lap.
I remember about 2 years ago, the EEOC had published that EEOC or EEO training in general in the employment area was ineffective. So it's interesting that you point that out. And on that topic, that goes to personal responsibility. Could you share with the students what their personal responsibility or liability would be
of course.
as managers and HR professionals with a degree?
Yeah. Well, let me just clarify that comment that they made about training being ineffective. That was specific to a 6-year study and report that they published that focused in on the issue of sexual harassment. So it wasn't necessarily them saying that all employer training is not good, but they were really focused on the sexual harassment issue and saying, whatever you people are doing in terms of sexual harassment training, it's not working. The numbers are still completely out of control. And all of this kind of dovetailed with Me Too. So just to clarify that, don't stop training because it's actually very helpful. And as a lawyer, I would encourage you to do it, because if you do find yourself at the receiving end of one of these claims, part of your defense is going to be, we did do the training. We were reasonable. We had the right kind of policies and complaint mechanisms and investigations and training to prevent this stuff. And the employer that has done those things will fare much better in litigation than the one who did nothing. But let's talk about liability. And I'm so glad you brought that up, because this has changed just in my life and time since I graduated from college back in 1980. When I first came out of college, most of the liability issues tracked very closely with the language in each individual statute, whether it be Title VII or the ADA or the ADEA. And it clearly states that if you feel like your rights have been violated, the person that you take to task is the employer. And the employer was specifically defined to be the employing entity. It's no single person. And what that meant was you don't file the lawsuit against the person who discriminated against you or anybody else who was involved in the process of trying to remediate it. But that has changed over the years in a number of ways. One of the ways is that individual states have state laws which are more protective of individual rights, and so they preempt the federal definitions, and they make clear that yes, individuals can be sued. Other ways that the law has morphed is just reinterpreting the existing law, using kind of novel theories of liability like aider and abetter. But the bottom line is that it's very clear that these employment cases can be brought against individuals. So who are we going to sue? Well, obviously, the first person that they're going to go after is the person that they feel most directly harmed them. In a harassment case, that's going to be a harasser. In a hiring case, it's going to be the hiring manager. But other people that have been successfully individually sued are, let's say, an existing employee had a complaint, told their manager, and the manager either didn't handle it properly, didn't handle it at all. The manager can be named as to have individual liability. Also, the HR person, if in fact they knew about it and they had an inadequate response. not a robust enough investigation, either insufficient or no remediation effort whatsoever. And I have seen over the years, and the numbers just keep kind of edging up, not at steep peak, but they're edging up as to successful claims against managers and human resource people who were in the picture, knew what was going on, were insufficient in their responses to whatever the complaint was, be it discrimination or harassment. And I will say all along, the wage and hour laws have been written in a manner where the employer is clearly more than just the entity. It says anyone who makes a decision on behalf of the employer. So once again, we're pointing our finger at managers, supervisors, and HR people.
I think one of the things that you mentioned is a really important distinction that students and even new HR professionals don't really understand why they need an employment law attorney. You've got the static law and then you've got the case law. Can you explain, because you mentioned the reinterpretation of existing law. Yeah. Can you explain why an employment law attorney is really needed in a lot of situations?
Yes. And I wish there was a single place that you could go and just immediately find the answer to your question. But employment law questions tend to be nuanced, and you're already under the gun because, well, let me put it this way. When I first started doing HR work back in 1980, it was probably sufficient to have your mind wrapped around the federal law. So when you were making, decisions, or when you were writing a new employee handbook or employment agreements or anything like that, as long as you understood the federal law, you were probably just fine. What has happened in the meantime is that states and even local governments have become much more active in regulating these issues. So especially an employer who is multi-state, who has operations outside of Texas, and they've got people in other states, now you have to have a good understanding of what is not just the federal law, what is the law of every state where I have people, what is the local law of where they live and work. And it changes and then, so that's just the statute. That's just the what we call black letter law. That's what was, written by the Congress and the legislatures. Layered on top of that, you've got your administrative agencies. So for instance, the EEOC is the federal agency that enforces Title VII, ADA, ADEA. Well, they've put out all sorts of regulations, which are not the law, but they give you a very clear picture of what they consider to be a violation of the law. So it's of a certain quality. Then after that, you've got the written guidance that they put out that's not quite as heavy hitting as the regulations, but again, it puts more meat on the bone to help you understand what your obligation is. So you've got 3 different levels of government in terms of federal, state, local, and then you've got black letter law plus regulations plus guidance. And then let's add another layer just to make it more fun. Now you have the courts. We're back to basic civics. You've got 3 branches of the government. Well, don't leave the courts out, because that's what courts are all about. They interpret what those laws were meant to be. Sometimes the enforcing agency gets it wrong. Sometimes they overstep, and the judges will push back on them and said, no, that's not what Congress said. So you have to wrap your mind around, on top of all this other stuff, what these court cases are and whether or not they have changed how the law is actually applied. And a lot of this stuff is happening at the speed of light. I'll just use COVID as an example in terms of local and state legislation and regulation. All of a sudden, HR was faced with a ton of mandates coming at them from every which direction in terms of the FFCRA and paid time off and protected time off, and whether or not you have to wear a mask, and whether or not you can't even come to work anymore. And this stuff was just flying. And then in terms of some jurisdictional areas, especially out in California, where they already had several layers of different types of paid time off, which applied. And now you had to layer these temporary paid time off measures that were specific to COVID and see how they interfaced with the existing law. It's a lot to keep up with. It's more than a full-time job for me. And, as an HR person, you weren't hired to try to wrap your head around and stay on top of all of the developing law. And there's a lot to it. It's very complicated. So yeah, your labor and employment lawyer is probably your best friend and your best sounding board when you're fixing to make a decision that will impact somebody's employment, just to make sure you're doing the right thing.
So to wrap everything up, looking at the staffing process, the hiring process, what do you think are the typical mistakes HR professionals or managers make related to EEO or the hiring process?
Oh, that's a great question. And I actually went to that EEOC website just to look at their charge statistics and just look and see where were most of the charges being filed. And they, in the area where they break it down by employment activity, the two that most closely fit with staffing would be advertising and hiring. Advertising, they've got statistics that are listed between 2010 and 2020. And there really aren't a lot of charges. So it feels like to me, the actual recruitment ads aren't necessarily resulting in a lot of charges. I will tell you an example of one thing you don't want to do. Clearly, we don't want to have like the old timey ads that's, specify that you're only hiring females or you're only hiring males. I think we've all moved past that and we know that's not cool. But one that some employers trip up on is where they advertise and they say that they're seeking recent college graduates. And I know what's on their heart. They're thinking, well, I have this training program when I bring these people in that's going to show them all the ropes of my business. And the ideal person is somebody who's fresh out of college. And I want to give them that opportunity and actually enhance their skill set by putting them in my specialized, like computer programming or systems engineering development program. Well, you didn't mean it, but when you said recent college graduate, for the most part, you're sending a clear message that you don't want anybody over the age of like 24, 25. And so, and not to say that there aren't older people that attend college, but that's what it seems to hint at. And the EEOC, whenever they see that, they hop on it fast. And thankfully, for the most part, they'll just call the employer and say, you might not want to run that ad again, and here's why. But that's a common mistake that happens. Other things that pop up are, if not the ads, a lot of companies have referral bonuses for their employees if they refer a friend or family member and that person gets hired. And there's nothing per se wrong with those, but if you have a workplace that's already imbalanced, for instance, based on race, and you're getting most of your new hires by referrals from your existing workforce, guess what? You're going to perpetuate that imbalance. So believe it or not, employers' referral bonuses have been a bone of contention, not for all employers, but for certain employers. Interviewing is another opportunity where an untrained either manager, supervisor, or someone who was just pressed into service to be on the interviewing team asks inappropriate questions. And I'll share one case with you that I use when I do training because I think it's particularly illustrative of this. So there was this Chevy dealership in Illinois, and they had run an ad that they needed more salespeople. And an older gentleman who was Black responded to the ad. He came to the dealership. Normally the HR person does the interviews, but that person was absent that day. And so the general manager grabbed a couple of sales guys off the floor and said, HR's not here today. Can you interview this guy? Let me know if you think he can sell. Well, these guys, who turns out they were all white and relatively young, started asking him questions like, well, are you planning on retiring anytime soon? And another question they asked was, are you going to have a problem with being supervised by someone who's older than you? And I'm sure they thought those were fair questions. They probably even thought they were job related. But anyways, the guy didn't get the job. We're all human beings. We have feelings, and our feelings do get hurt. And when most people don't get the job, they don't say to themselves, oh, I'm sure somebody better qualified than me got the job. That's not how we react to it. We poke and probe and we try to remember, well, that's not right. And he remembered these questions. And long story short, he went into court, he sued, the dealership lost. And in the decision that the judge wrote, one of the things that he said was, it is a critical mistake for employers not to train anybody who's involved in the hiring process and at least the basics of employment law, that is a serious mistake to make, to the point where it justified not just compensatory damages, but punitive damages, which tend to have lots of zeros to the left of the decimal. So just a message that it is so important for people that are involved to have this basic understanding, and even just a list of what questions not to ask. I'll give you a resource for that. A lot of states, and I think it's even on the Texas website as well, whatever your state employment agency is, for us, it's the TWC, Texas Workforce Commission. In other states, it has slightly different names, but a lot of them actually post on their websites, here's a list of inappropriate questions. And some of them take the next step and say, and to contrast and compare, here's the right way to get at the information that you're actually fishing for. So for instance, it's an inappropriate question to ask somebody, well, do you own a car? And what you're getting at is, do they have reliable transportation to get at work? And so the better question would have been, do you have a reliable way to get yourself to work every day? You know, one has a disparate impact on people who are low income, which sometimes implicates racial minorities. It can also implicate gender, where there's been a divorce and somebody was on the losing end and they don't have a whole lot of money and they don't have a car anymore. I mean, nobody thinks that they're deliberately discriminating. They honestly just stumble into it, but that's not a defense. The I didn't know and I didn't mean anything by it, that's never a defense. So yeah, you want to educate the people that are involved in the interviewing process and make sure they don't make those mistakes. The last one I'll mention is pre-employment testing. And there are a ton of vendors out there that will sell you products that are designed to determine whether or not this person, many of them refer to cultural fit for your organization. And those tests have been the subject of much litigation by the EEOC, but also private lawsuits. And here's the problem. Sometimes it's the questions that are being asked are just flat out implicate various protected categories. Like I saw one that says, you know, what are your religious beliefs? Like, hello, that has nothing to do with my ability to do your job. So the questionnaire itself was the problem. Sometimes the problem is the way that the tests are scored. If you set the bar too high, too low. The biggest problem, and this is what I see again and again, is the vendor your defense in using the test is that the test was validated, that you actually have proof to show that it is a reliable indicator of whether or not the person will be successful in these particular tasks. And the vendor will tell you, well, yeah, I've got a validated test. No, it has to be validated specific to the employer who's using it. At a minimum, it has to be validated specific to the types of job or the industry. And they don't do that. They don't even get close to that. So beware of the vendor who says, yeah, I've got a validated test. Start asking them how it was validated, who validated, when was it validated, against what pool was it validated. You know, I mean, we can really get into the weeds of whether they use cost, construct, criteria, you know, what was the method of your validation. So anyway, beware of pre-employment testing, particularly those that are supposedly looking for cultural fit.
So can you just backtrack real quick and expand on disparate impact? The students are just being introduced to that concept.
Oh, okay. So basically, under all of the employment discrimination laws, there's two ways that you can discriminate against somebody. The first one is called intentional discrimination, and that's when you put your hand on your hips and say, I'm not going to hire any women. So you intentionally discriminated against women. You intentionally made an employment decision based on gender, which is a big no-no. We all know that. And most people don't do that anymore. I mean, unless they're just grossly uninformed. For the most part, people don't do that. But the other way they can trip over that line is something we call disparate impact. And that is that your employment processes, your interview questions, your testing, whatever, was completely neutral. There was no reference whatsoever to a protected category. However, the impact of that tool, whatever it was, the test, the interview, is that a particular cohort was disproportionately excluded. So I didn't specifically exclude women, but there's something about my hiring process that for some reason, I'm not hiring very many women, I'm hiring all guys. And it's just a statistical exercise. And the statistics is what they use as the evidence to prove that that employer has in fact engaged in disparate impact. So there's a number of ways to, I mean, one is just to be very critical about your processes, to track, you know, your applicants, your hiring, who was hired, who was excluded, see if you see any patterns that make you uncomfortable. I know one of the things that I do as a lawyer very often, it's kind of at the other end of the process, but when somebody's getting ready to do a reduction in force, they send me the list of the people who were in the pool that could have been picked for RIF, plus the attributes of the ones who were picked for RIF. And I do a 2 standard deviation analysis to see, did you inadvertently have these decisions fall more heavily on people based on either their gender, their race, or their age? And if your underlying decision making is good and well documented, well, I picked this one because they've had terrible performance reviews for the last 4 years, then you're probably going to be fine. But if you don't have that underlying support, then that's where the statistic is going to leave you in a bad place with no defenses.
Okay, so to wrap this up, anybody in the group who is interested in your job and becoming an employment law attorney, what are your suggestions for a career path?
Oh, wow. So mine is a bit unusual. I would say the vast majority of lawyers went to law school directly from undergrad. My path was different. I worked in HR for 11 years and then went to law school when I was in my 30s. For me, it worked out great. And I will tell you that when it came to the end of law school and we were all out there looking for our first jobs, either with a law firm or an agency or a corporation, I will tell you, I had a huge leg up because I had 11 years of practical work experience that was relative to the type of practice that I was seeking. So I don't regret it for a minute that I had that good working experience prior to going to law school. Another little benefit is that I noticed that some of my classmates that went straight through, you know, high school, undergrad, law school. I mean, I think some of them were getting close to being burned out. They were very tired and just, you know, sometimes they were losing their focus, and, you know, and a fair number of them quit law school. You know, this isn't for me. My approach was entirely different. I'd been out in the working world for 11 years, and I was so excited that I could wear tennis shoes and shorts to school every day. And, you know, it was a new thing, and for me, it was fresh and exciting. And, you know, I just gobbled it up. It's unusual to come to the practice of law in that manner, but it can be done. And I've also seen people flip the other way too. I've also seen people who are lawyers, and at some point they grew tired of practicing law. This happens probably more often to litigators because that's you're litigating and you're in constant battle mode, and sometimes that just tends to wear you out a little bit. It's not for some people revel in it, some people it just wears them out. And I've seen a number of those people actually go into HR. So these are former lawyers who are now HR people for companies or for, you know, government agencies or, you know, whoever. So it can go either way, but yeah, HR is a tough thing to break into because there's so much that you need to understand and be able to do. And so anything that you can do to gain that practical experience before you go job searching is all to the good.
Well, I really appreciate your time. Thank you, thank you, thank you so much for talking to our students.
It was my pleasure. Thank you, Dr. McPherson. It was wonderful to see you, and I wish all of you a wonderful school year. And if I can be a resource to you, don't hesitate to reach out.
Thank you.